Do y'all need the exhibits out for your closing?
I don't plan on using them. Well, maybe some of the photographs.
How about y'all? State?
We have
Texas.
Adam Levin and Amy Owen for the defendant, Your Honor.
All right, have both parties had a chance to review the jury charge?
Yes, Your Honor.
The defense has as well, Your Honor.
Any objections?
No objection from the state.
None from the defense, Your Honor.
All right, let's bring the jurors in.
All right, for the jury.
And does anybody want a time?
She's gonna watch them.
Okay. Oh, please be seated. All right, everyone. I am sorry about our late start. Our late start is due to things outside of our control with maintenance and the flooding that's happening in the building. I'm going to read to you the charge of the court. After I read the charge of the court, both parties, if they choose, will have a chance to give closing arguments to you. You do not need to memorize the charge that I'm going to read to you because you will be given the original when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Shelby Jean Rodriguez, is charged in count 1 of the indictment with the offense of aggravated assault with a deadly weapon, alleged to have been committed on or about November 5th, 2023 in Bexar County, Texas. The defendant, Shelby Rodriguez, is charged in count 2 of the indictment with the offense of aggravated assault with a deadly weapon, alleged to have been committed on or about November 5th, 2023 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. 1. Our law provides that a person commits an offense if the person intentionally or knowingly threatens another with imminent bodily injury. A person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. 2. Deadly weapon means a firearm or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 3. A person acts intentionally or with intent with respect to the nature of her conduct when it is her conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to the nature of her conduct or to the circumstances surrounding her conduct when she is aware of the nature of her conduct or that the circumstances exist. 4. Self-defense. You're instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree she reasonably believes the force is immediately necessary to protect herself against the other's use or attempted use of unlawful force. The use of force is not justified in response to verbal provocation alone. You are instructed that the threat of force is justified when the use of force is justified. A threat to cause death or serious bodily injury by the production of a weapon or otherwise, as long as the actor's purpose is limited to creating an apprehension that she will use deadly force is necessary, does not constitute the use of deadly force. You are instructed that the defendant's belief that the force was immediately necessary is presumed to be reasonable if the defendant, 1, knew or had reason to believe that the person against whom the force was used was attempting to commit murder. Murder is defined as intentionally or knowingly causing death of an individual. And 2, the defendant did not provoke the person against whom the force was used. And 3, the defendant was not otherwise engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the force was used. The presumption of reasonable belief applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the jury must find that the presumed facts exist. If the jury has a reasonable doubt as to whether the facts giving rise to the presumption do not exist, the presumption applies and the jury must consider the presumed fact to exist. Even if the jury finds that the state has proven beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged in the indictment. A person is justified in using deadly force against another, one, if the person will be justified in using force against the other in the first place, as set out above, and two, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect herself against the other's use or attempted use of unlawful deadly force. Reasonable belief means a belief that will be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person has a right to defend herself from apparent danger to the same extent as she would had the danger been real, provided she acted upon a reasonable apprehension of danger as it appeared to her from the standpoint at the time. A person, one, who has a right to be present at the location where the force or deadly force is used, and two, who has not provoked the person against whom the force or deadly force is used, and three, who has not engaged in criminal activity at the time the force or deadly force is used, is not required to retreat before using force or deadly force. If all three of these factors are met, then in determining whether such actor reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. The defendant is not required to prove self-defense. The state must prove beyond a reasonable doubt that the defendant's conduct was not justified by self-defense. 5, count 1, aggravated assault with a deadly weapon, firearm. Now, if you find from the evidence beyond a reasonable doubt that on or about November 5th, 2023, in Bexar County, Texas, the defendant, Shelby Jean Rodriguez, did use or exhibit a deadly weapon, namely a firearm, and Shelby Jean Rodriguez did intentionally or knowingly threaten imminent bodily injury to Anthony James Rodriguez by pointing said deadly weapon at or in the direction of Anthony James Rodriguez, then you will next consider whether the defendant, Shelby Jean Rodriguez, was acting in self-defense at the time and skip to paragraph 7. Do not consider paragraph 6. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Shelby Jean Rodriguez, not guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and proceed to paragraph 6 to next consider the lesser included offense of misdemeanor deadly conduct. Number 6, count 1, lesser included offense of misdemeanor deadly conduct. A person commits an offense if she recklessly engages in conduct that places another in imminent danger or serious bodily injury. Serious bodily injury, as defined in paragraph 2, applies and has the same meaning here. A person acts recklessly or is reckless with respect to the circumstances surrounding her conduct or the result of her conduct when she is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. You are instructed that recklessness and danger are presumed if the actor knowingly pointed a firearm at or in the direction of another, whether or not the actor believed the firearm to be loaded. With regards to some such presumption, you are instructed, A, that the facts giving rise to the presumption must be proven beyond a reasonable doubt, and B, that if such facts are proven beyond a reasonable doubt, you may find that the element of the offense sought to be presumed exists, but you are not bound to so find. And C, that even though you may find the existence of such element, the state must prove beyond a reasonable doubt each of the other elements of the offense charged. And D, If you have a reasonable doubt as to the existence of a fact or facts giving rise to the presumption fails, and you shall not consider the presumption for any purpose. Thus, with regards to the lesser included offense of misdemeanor deadly conduct under count 1, if you believe from the evidence beyond a reasonable doubt that Shelby Jean Rodriguez knowingly pointed a firearm at or in the direction of another, whether or not Shelby Jean Rodriguez believed the firearm to be loaded, recklessness and danger are presumed, and you may find as such. However, you are not bound to so find, and even if you do, the state must still prove beyond a reasonable doubt that each and all of this and the other elements of the offense of misdemeanor deadly conduct. And if you have a reasonable doubt that Shelby Jean Rodriguez knowingly pointed a firearm at or in the direction of another, the presumption fails, and you are not to consider the presumption for any purpose. Therefore, if you find from the evidence beyond a reasonable doubt that on or about the 5th day of November 2023 in Bexar County, Texas, the defendant, Shelby Jean Rodriguez, did recklessly engage in conduct that placed Anthony James Rodriguez in imminent danger of serious bodily injury, then you will next consider whether Shelby Jean Rodriguez acted in self-defense and proceed to paragraph 7. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of misdemeanor deadly conduct under count 1, and do not consider paragraph 7, but skip to paragraph 8 to next consider count 2. 7, self-defense as to count 1. Keeping in mind the instructions on self-defense given in paragraph 4, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed either the offense of aggravated assault with a deadly weapon, as in charge count 1 of the indictment, or the lesser included offense of misdemeanor deadly conduct under count 1, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense with regards to count 1. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed either the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, or the lesser included offense of misdemeanor deadly conduct under count 1, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time she did so, 1, Shelby Jean Rodriguez reasonably believed, or is presumed to have reasonably believed, as viewed from her standpoint, that Anthony James Rodriguez was using or attempting to use unlawful deadly force against Shelby Jean Rodriguez, and 2, Shelby Jean Rodriguez reasonably believed, or is presumed to have reasonably believed, as viewed from her standpoint, that her threat to use deadly force with a firearm and the degree of threat were immediately necessary to protect herself against Anthony James Rodriguez's use or attempted use of unlawfully deadly force, and 3, Shelby Jean Rodriguez's threat to use deadly force with the firearm was not in response to verbal provocation alone, then you will find in favor of the defendant, Shelby Jean Rodriguez, on her claim of self-defense, and say by your verdict not guilty of count 1. However, if you find from the evidence beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed either the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, or the lesser included offense of misdemeanor deadly conduct under count 1, and you further find from the evidence beyond a reasonable doubt that 1, Shelby Jean Rodriguez did not reasonably believe and is not presumed to have reasonably believed, as viewed from her standpoint, that Anthony James Rodriguez was using or attempting to use unlawful deadly force against Shelby Jean Rodriguez, or 2, Shelby Jean Rodriguez did not reasonably believe and is not presumed to have reasonably believed, as viewed from her standpoint, that the threat to use deadly force with a firearm degree of threat were immediately necessary to protect herself against Anthony James Rodriguez's use or attempted use of unlawful deadly force, or 3, Shelby Jean Rodriguez's threat to use deadly force with the firearm was in response to verbal provocation alone, then you will find against the defendant, Shelby Jean Rodriguez, on her claim of self-defense under count 1. If you have found from the evidence beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and have found against the defendant on her claim of self-defense, then you will find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in count 1. If you have found from the evidence beyond a reasonable doubt that the defendant Shelby Jean Rodriguez committed the lesser included offense of misdemeanor deadly conduct under count 1 and have found against the defendant on her claim of self-defense, then you will find the defendant guilty of the lesser included offense of misdemeanor deadly conduct under count 1. All right, ladies and gentlemen, if you'll just give me a moment, I'm gonna have you step in the jury room just briefly, and then I will bring you all back out. Everyone, please rise for the jurors. All right, everyone, please be seated. So, please be seated.
It's okay, but then,
Oh, sure.
sorry.
All right, so as you all know, that in the courthouse yesterday, there was a sewage leak. My understanding, there was sewage on the first floor, maybe it came from the second floor. Now there are other major leaks in the building. I don't want to say that I had continued to tell them, there's a stench on the second floor. And attorneys who have been practicing for a while, you know, there was always the stench on the second floor. They sort of repaired it, but didn't repair it. Am I correct? No, they sort of repaired. Yeah. Yeah, no, you can. So they sort of, oh yeah, you can, well, this part is going to have to be on the record.
Right now?
Yes.
Okay, hold on.
Yeah.
Go ahead, Judge.
So as you know, they sort of repaired it and didn't repair it. So now this is where we are. They are shutting down the Justice Center because they say it is a biohazard. Now, when you put the word bio and hazard together, that is not a good thing.
No.
So is there any objection to, they're shutting down the Justice Center unless there's somewhere else we can go, which I don't believe they have a place that we can go. I can call the district court admin and see if there's a place to go. Otherwise, the other suggestion is for us to continue this on Monday. So I want you all to discuss.
I have a suggestion, and on the record, author, it doesn't make a difference.
Yeah, we're on the record.
The 288 district court is just down the hall, and it's in the Paul Elizondo Tower. I don't think they're actually occupying it today.
Well, let me call.
I think like they're out. I don't think anyone's using that courtroom. Yeah, it looked like the door was closed. And
All right, so we're gonna let me call district court admin to see if there's a court available. Otherwise,
Your Honor, just one thing.
Yes.
Where are the jurors gonna deliberate if we go?
Oh, they have a room.
Okay,
Yes.
I've never been, so I just.
Yes,
didn't
no,
know.
they have one.
Or the other option, I'm just gonna throw it out there. We have 2 impact courts, which I don't believe ever hold docket on Friday. They're also in Elizondo Tower.
Let's see. Let me call court admin and see what we can do.
The defense's thing, I'd like to see if we can get
All right, everyone, please be seated. So ladies and gentlemen, the reason why I called for a break is because I've been checking the emails and keeping both the state and the defense informed of whether or not water is on the fourth floor. So water is not on the fourth floor. If water were to come to the fourth floor, I wouldn't say if or before waters even think of touching this floor, you all will be doing your deliberation not in the 187th jury room. We'll have a different place for you to do your deliberations. Does everyone understand? All right, so I'm going to continue reading the charge. 8, count 2, aggravated assault with a deadly weapon, knife. Now, if you find from the evidence beyond a reasonable doubt that on or about November 5th, 2023 in Bexar County, Texas, the defendant Shelby Jean Rodriguez did use or exhibit a deadly weapon, namely a knife that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Shelby Jean Rodriguez did intentionally or knowingly threaten imminent bodily injury to Anthony James Rodriguez by pointing said deadly weapon at or in the direction of Anthony James Rodriguez, then you will next consider whether the defendant, Shelby Jean Rodriguez, was acting in self-defense at the time, skip over paragraph 9, and proceed to paragraph 10. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Shelby Jean Rodriguez, not guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, and proceed to paragraph 9 to next consider the lesser included offense of misdemeanor assault. 9, count 2, lesser included offense of misdemeanor assault. Now, if you find from the evidence beyond a reasonable doubt that on or about November 5th, 2023 in Bexar County, Texas, the defendant, Shelby Jean Rodriguez, did intentionally or knowingly threaten imminent bodily injury to Anthony James Rodriguez by pointing a knife at or in the direction of Anthony James Rodriguez, then you will next consider whether Shelby Jean Rodriguez acted in self-defense and proceed to paragraph 10. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of misdemeanor assault under count 2 and do not consider paragraph 10. 10, self-defense as to count 2. Keeping in mind the instructions on self-defense given in paragraph 4, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed either the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, or the less included offense of misdemeanor assault under count 2, you must decide whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense with regards to count 2. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed either the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, or the less included offense of misdemeanor assault under count 2, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time she did so, 1, Shelby Jean Rodriguez reasonably believed or is presumed to have reasonably believed, as viewed from her standpoint, that Anthony James Rodriguez was using or attempting to use unlawful deadly force against Shelby Jean Rodriguez, and 2, Shelby Jean Rodriguez reasonably believed or is presumed to have reasonably believed, as viewed from her standpoint, that her threat to use deadly force with a firearm and the degree of threat were immediately necessary to protect herself against Anthony James Rodriguez's use or attempted use of unlawful deadly force, and 3, Shelby Jean Rodriguez's threat to use deadly force with a firearm was not in response to verbal provocation alone, then you will find in favor of the defendant, Shelby Jean Rodriguez, on her claim of self-defense and say by your verdict not guilty of count 2. However, if you find from the evidence beyond a reasonable doubt that the defendant, Shelby Jean Rodriguez, committed either the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, or the less included offense of misdemeanor assault under count 2, and you further find from the evidence beyond a reasonable doubt that 1, Shelby Jean Rodriguez did not reasonably believe and is not presumed to have reasonably believed, as viewed from her standpoint, that Anthony James Rodriguez was using or attempting to use unlawful deadly force against Shelby Jean Rodriguez, or 2, Shelby Jean Rodriguez did not reasonably believe and is not presumed to have reasonably believed, as viewed from her standpoint, that the threat to use deadly force with a firearm and degree of threat were immediately necessary to protect herself against Anthony James Rodriguez's use or attempted use of unlawful deadly force, or 3, Shelby Jean Rodriguez's threat to use deadly force with a firearm was in response to verbal provocation alone, then you will find against the defendant Shelby Jean Rodriguez on her claim of self-defense under count 2. If you have found from the evidence beyond a reasonable doubt that the defendant Shelby Jean Rodriguez committed the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment, and have found against the defendant on her claim of self-defense, then you will find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in count 2. If you have found from the evidence beyond a reasonable doubt that the defendant Shelby Jean Rodriguez committed the lesser included offense of misdemeanor assault under count 2 and have found against the defendant on her claim of self-defense, then you will find the defendant guilty of the lesser included offense of misdemeanor assault under count 2. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine their own views and change their opinion if convinced it is erroneous. However, no juror should surrender their honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or other charged with the offense gives rise to no inference of guilt at her trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you in these instructions, you will acquit her and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is not guilty or guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is not guilty or guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 Judicial District Court, Bexar County, Texas. Suitable forms are attached. State, are you prepared to proceed?
We are, Your Honor.
All right, you may proceed.
Please the court, please counsel. Good morning. We thank you for your time in this case. I know the judge just read a very lengthy document to you. You are going to have it with you when you go back, so don't feel like you have to memorize it or anything. But I did want to take the time to explain just a few things to you. On page 1, it talks about assault, and assault is when a person threatens another with imminent bodily injury. That threat can be with words, I'm going to effing kill you, or actions by pointing a gun at you or by thrusting a knife downward motion in your direction, okay? Next, I want to talk about deadly weapon. We had several witnesses testify that the gun in this case is a deadly weapon. It is a firearm capable of causing death and serious bodily injury. Same with a knife being thrust at you is capable of causing death or serious bodily injury. Serious bodily injury, as I said, can be caused by a gun, like the defendant said, and like our complainant said, being pointed in central mass, which is going to cause very serious bodily injury and potentially death. One thing I wanted to talk to you about are the mental states that were noted in the charge, intentionally or knowingly. That is not what you intended to do with the gun. That is not what you intended to do with the knife. It's what did you intend your conduct to be? Did you intend to raise the gun and point it? Did you intend to raise the knife and thrust it at Anthony? That's what that mental state goes to. Not were you going to shoot, not were you going to stab. Did you intend for your arm to raise and point the gun? Did you intend for your arm to thrust the knife? Okay. The other thing I'd like to talk to you about, we get questions about this all the time. The reports that the witnesses use to refresh their memory for their testimony, those are not going to go back to you. Okay, those were not entered into evidence. The only evidence that will go back with you is what was offered and admitted into evidence, okay? And you will have that with you back there. The other thing I'd like to talk to you about is credibility. That is directly within your purview. That's credibility of every witness that testified, including the defendant. She doesn't get extra points for testifying. You get to judge her credibility just like you would judge Anthony's, just like you would judge any of the officers that testified, okay? So next, I'd like to go through and simplify page 7 through 18. That was all of the counts, the self-defense, the lesser included, just to kind of make that a little easier. You look first to see if we proved count 1, aggravated assault with a deadly weapon by pointing a gun and threatening Anthony. If you find him guilty, then, if you find her guilty, then you determine self-defense, okay? If you say not guilty, then you go to the lesser included offense of deadly conduct. right? So deadly conduct is when you recklessly engage in conduct that places another in serious bodily injury and at risk of serious bodily injury. Kind of the same elements as ag assault, deadly weapon, but recklessness and danger are presumed if you knowingly point a gun at somebody, which we have here, okay? So again, determine if we've proven ag assault, deadly weapon. If you find her guilty, then you go to self-defense. If you find her not guilty, then you go to the lesser included offense. If you find her guilty of the lesser included offense, then you consider self-defense, okay? And that's going to be the same for count 2. You determine if we've proven her guilty of aggravated assault with a deadly weapon by pointing a knife at Anthony and thrusting it in his direction. If you find her guilty of that, you go to self-defense. If you find her not guilty of that, you go to the misdemeanor offense of assault, which is going to be the same elements, pointing the knife at Anthony, okay? If you find her guilty of the lesser included offense, then you go to self-defense. So, have we proven all of our elements to you? I'm going to submit to you that we have. Not only did Anthony come up here and testify that they got into an argument, she was angry, she thrusted the knife at him, and when that wasn't enough, she went and got the gun and pointed it at his head and said, "I could effing kill you." That is aggravated assault with a deadly weapon. That is also deadly conduct. That is also aggravated assault with a deadly weapon with a knife. We have proven each of those elements to you, not only from Anthony's mouth, but also from the defendant's mouth. Because in order to claim self-defense, she has to admit to each of those elements, and she did. So let's talk about self-defense here. When you're just deliberating on whether she was acting in self-defense, I want you to think about credibility, okay? Consistency in her story. From that date of the offense, you're gonna get that clip that we showed you back there with you. Please watch it. Listen to the words that she's telling the officers hours after this happened. Look at her demeanor in that clip. Look at her actions in that clip, okay? Look at the details she gives in that clip. Look at who has a motive to lie. She's facing some pretty harsh charges here. She does have a motive to lie. She has had 2 years of preparation to come up with what she put on the stand for you to judge. But let's just say, even if you do believe her story, I want to talk to you about apparent danger. Okay, apparent danger is something that is in the self-defense description. Basically, you don't have to wait for somebody to stab you before you try and take a knife away. So even if you believe her story, that they were this close together and she has a knife in her hand, in her right hand, and she's talking with her hands and she's yelling and they're fighting and she's angry, Anthony doesn't have to wait for her to stab him. He can go for that knife. He can try and defuse the situation. He was acting in self-defense, if you believe her story. Ladies and gentlemen, I submit to you that we have proven each and every element beyond a reasonable doubt. I ask that you find her guilty of aggravated assault with a deadly weapon in count 1 and count 2.
All right, defense, are you
Your
ready?
Honor, I apologize. You do reserve the rest of our time.
All right, defense.
Yes, Your Honor. And please support counsel. Good afternoon, ladies and gentlemen. Thank you again for being here. I know we got off to a later start today than we had wanted. That's nobody's fault. I know it's an inconvenience to all of you, and you have my appreciation for being here. We are here today, closing arguments, the state of Texas versus Shelby Rodriguez. Talk about burdens of proof. We talked about this in Bordier. We're going to go into this more and more. Burden of proof is always on the state, and they must prove each and every element, all elements of an offense. And each element must be proved beyond a reasonable doubt. Most importantly, is that self-defense was not justified in this case. We are not denying that Shelby pointed a gun at Anthony Rodriguez that day. You heard her tell you that. The question is why? And the reason she did it is quite simple. She was in fear for her life, and her life was in danger. We showed you a few photographs, and you'll have these back there. Defense Exhibit 1, which we entered. The state didn't enter this, defense did. You see a Band-Aid on her arm, and you saw the wound when she took her blazer off to show it to you, right? You see a scar there. happen when they're struggling for a knife. She gets poked or stabbed or cut. Then we have defense exhibit 2. Blood on the hands. It was documented, and thank God it was documented, because it lends credence. It proves what she was saying was true. She's sitting there, she's talking, they're having a heated conversation. She's not trying to stab Anthony. He even says, I felt no real danger at that point. You know, she's across the counter, etc. At some point, he comes across, knife goes up, she gets her hand gets cut. She immediately goes for a weapon. Back the fuck off, is what she said. Pardon my language, but that's what she said. And why did she do it? It's quite simple. Her life was being threatened by a knife. You don't have to sit there and become a victim. You don't have to become a statistic. If somebody threatens your life, you have the right, I would say you have the duty to stand up for yourself. And that's what Shelby did. We talked about this before, just how high of a burden of proof it is. I can't tell you what number to place on beyond a reasonable doubt. All I can tell you is it's much greater than 50%. It's higher even than clear and convincing, which we talked about before. It's enough to take a child away from their parents. This is the highest burden of proof in the state, in the country. State has to prove this case beyond a reasonable doubt. Not only that aggravated assault happened, but more importantly, that this wasn't self-defense, and they have utterly failed in that measure. Again, as she stands there today, Shelby is presumed innocent. It is the only presumption that we have in a criminal case, right? And why is this important? Quite simply, it's because we don't make the accused prove their innocence. The state must overcome it, and they must prove that they're guilty. And more importantly, they must prove beyond a reasonable doubt that self-defense was not justified, that the use of deadly force was not justified. You measure it in the manner of what Shelby thought was reasonable in that time. And absolutely it was reasonable. I think anyone would say if you have a knife put up to your neck and you have a firearm available, you're going to go for that firearm. You're going to go there to help diffuse the situation, to protect your life, to protect your liberty. Anthony's on a mission. You say he didn't feel threatened by Shelby with a knife. She's across the counter. State wants you to believe that she's somehow making a stabbing motion. You heard Shelby talk. She had a knife in one hand. She had a towel in the other. They're doing the dishes, right? Just because somebody's holding a knife, you're doing the dishes, this doesn't give you justification to think that your life is in danger and threatened, right? There was no threat there. She simply has the knife. She has the towel. Quite frankly, she was forthcoming on the towel. She didn't say it on direct examination because I didn't ask it for her, okay? And I'll tell you this much. If there's ever something that I did wrong, something that you didn't like that I did, I'll accept that. But I ask you, don't take it out on my client and don't hold it against Shelby. After all this, you're going to have a chance to talk to all the attorneys, critique us, give us any advice that you have for us. But again, if there's something that I did that said to offend you, you didn't like, please, please, please don't hold it against my client. Again, Anthony's on a mission. He didn't feel threatened. That negates and disproves count 2 right there. In count 1, she was absolutely defending herself. You saw the blood on her hands. Keep in mind, these photos were taken hours later. She told you she had cleaned up. She was able to address her wounds. She was able to do this. Yet there's still drops of blood residual there. And again, thank God we have these photos because it shows and it proves what really happened that night. Again, you saw the defense enter this. This didn't come from the state because they knew it would destroy what was already a flimsy case. If you were on the fence, this absolutely puts a nail in the coffin. It shows that what happened this night was self-defense. Let's talk about what makes sense. By testimony, you have 3 hours. I think 2 hours and 45 minutes, 2 hours and 50 minutes. Again, we're talking something 2 years after the fact. We're not going to have exact timelines. But about 3 hours elapse, and Anthony doesn't call the cops. He says he doesn't know what to do. Folks, a child learns to dial 911, and a man with a master's degree certainly knows what to do. I have a 10-year-old niece. She knows. You call 911. If there's trouble, you call the police, right? you're mulling around for 3 hours, you're not sure what to do. Secondly, or lastly, we have it. Anthony's an admitted wife beater. We're going to be blunt about that. Incident happened years ago, but he slapped her. I don't know about you. I've never even thought about hitting a significant other. It's reprehensible to me. Family violence, unfortunately, does happen. This was not a happy marriage. This was not a healthy marriage. This was not healthy in any way or regard. But think about what that means and what it does to the credibility. You heard the prosecution say that you are the judges of credibility, and that is 100% correct. It is up to you to decide to believe any and all witnesses, one of them, none of them, it's up to you. That is a great responsibility and a great power that you have. What does this admission do, and what does it do to the credibility of Anthony Rodriguez? Again, he says he never calls the cops. He calls his mom. Then his family calls the police. And he said he's so afraid for his life that he was on his knees. According to Anthony, he leaves the house and his 3 children with someone that he wants you to believe was threatening to kill him. I don't know if any of you are parents. You have nieces, nephews. I don't have kids, but I have a niece that I adore. She's my entire life. If I thought for a second that she was in the slightest bit of danger, I would give my own life before I left her in a situation. Yet he's going to leave 3 children behind. Why is that? Because there was no danger. Shelby wasn't the one that was the aggressor. She stood up for herself. She stood up against an assault, and Anthony got caught. So why leave 3 kids behind? Because he knows that she's not crazy. He knows that she's not in danger. And again, 3 hours nearly elapses. Ask yourself what's reasonable in this case. And again, who in their right mind would leave any child behind? My apologies. You have 3 hours of time, plenty of time to call the cops, gather your children, and get out. Who cares about a bag at that point? You get your kids, you get out. You call 911 immediately. There was ample time to do this. You heard that the gun was put back in the cabinet. You go to the backyard, you grab your kids, you run to a neighbor's house, you do anything. You don't sit around and wait for 3 hours and mull it over if you truly think that your life is in danger. Shelby didn't call. And why is that? Because the danger left the house. The incident's over and her kids were safe with her. Again, Anthony didn't call the cops because quite simply he knew that he did wrong. Shelby fought back, and that is the only thing that is supported by the evidence in this case. You have the photographs of blood on the hands. You have Shelby telling you what happened. Knife went up to the throat, hand went up. The whole incident, she said, took about 10 seconds. That's probably right. It may have even been less, right? It happens in a flash of blink of an eye, but that's how quick it can take for somebody to lose her life. And Shelby absolutely defended herself the only way that she could have, and that is with the firearm. Thank you, ma'am. You have 3 possibilities in this case, and I'll tell you. And you got to forgive me if we were having technical difficulties, normally in animation. You have guilty verdicts. And let me explain kind of what you're looking at here. I don't know if you ever horse racing fans or dog racing, but you have a horse that's so far out ahead of the pack, that's not even close. We asked you who won the race. It's this horse right here, about 200 yards ahead, right? That's guilty. No question. You have not guilty. And then we have something we call not sure. Right here, you ever heard, finished by a nose, flash finish, you're not really sure who may have gone there. Not sure is not guilty. Any doubts that you have go to the benefit of the defendant, not to the state. But folks, I'm going to tell you, I don't think you have a doubt. I think it's pretty clear what happened here. Again, I'm going to tell you, we're not disputing that Shelby pulled the firearm on Anthony. In fact, I'm grateful that she did, because what she did was the only thing she could have done to defend her life in that moment. She was threatened with deadly physical force. You saw the blood marks on her hand from the cut, and she defended herself the only way she could have. Ladies and gentlemen, last but not least, I want to end how I started this whole process and say thank you. Sincerely and very much thank you for your time, your patience, and your consideration throughout this whole process. Ultimately, we'll also thank you for your verdict. And I hope and pray that y'all reach the right decision, the only decision which makes sense, and that is not guilty. Thank you very much.
All right, state you have 8 minutes and 16 seconds.
8 minutes, 16.
Yes.
Ladies and gentlemen, I want to address something right at the beginning. I want you to focus on why you are actually here. You are not here to decide whether or not Anthony Rodriguez is a good or a bad husband. You are not here to decide whether Anthony Rodriguez is a good or a bad father. Okay? Yes, he's cheated. Yes, he sinned. Morally and ethically, he broke his wife's trust. That does not give her the right to threaten his life, though. Okay? Focus on why we're here, to decide if an aggravated assault took place. So let's talk about how, indeed, an aggravated assault did take place. Okay? Like my co-counsel said, pointed a gun at his head, threatened to effing kill him, had a knife, stabbing towards him. Both of those are aggravated assaults. Next, you have her own words from that day. The clip that we showed you that you guys can go and take back to the jury room and watch. What does she say that day? Her words, I want the fucking truth, because he had been lying. So yes, I was like, I'm going to get my gun and I'm going to point it at you. I screamed at him and yelled at him and told him to get the fuck out of my house. Her words right there. Aggravated assault, both counts. Let's think how reasonable people act when they're in the heat of a moment. What do? As soon as they're having to bring this incident up, they spew out everything that's on their mind right there and then. You all know it. You're all reasonable people. We all get angry every now and then. Our anger is still at such a high level that whatever just happened comes out, the truth comes out. And then you're like, wait a second. What did I just say? Let me back up. Let me rethink what I have. What did I say? What came out of my mouth? Well, that's exactly what she did. Look on this video clip.
I told him I want the truth because he's been lying. So yes, I was like, I will get my gun and I will point at you. And I screamed at him and I yelled at him and told him to get the fuck out of my house. Because it's not with it.
It's not worth it. That right there is her knowing that she was caught. She was caught and she had to rethink right there. What sounds better for me? What sounds that makes me sound less guilty? The gun wasn't loaded. That came to her mind, as if that makes it better for her, right? She got caught and she tried to correct herself. Let's also talk about her claim of self-defense. All right. So her story is that they were in the kitchen. She had the knife. He was close to her because, in her words, he lunged at her. She had the knife in her right hand and he grabbed it and put it to her neck. Let me stop right there because so far I'm confused. Because yes, in defense's own exhibits, you're going to see, sorry, on this picture, where's the mark on her neck from this knife? He admitted there was no mark on her neck. That's for you to decide. You guys judge credibility, okay? But in continuing in her story of that, with the knife in her right hand, backs off a little. With that same hand, she reaches up and over a 6-foot fridge, opens the cabinet, and gets her gun with the same right hand that she said. Again, you decide credibility and if that makes sense. Also consider the fact, what co-counsel just said, she has had 2 years to get her story straight, to tell you something that makes her sound less guilty, makes her sound more credible. who's credible and who's consistent? Anthony Rodriguez is consistent. Okay, well, how do we know he's consistent? Well, defense tried to trip him up on cross-examination. He stuck to his story. He gave an interview with the first responding officer. You heard Detective Carrion testify. His job is to review the initial statement in the responding officer's report. He did. He then scheduled an interview of Anthony Rodriguez, and you heard Detective Carrion testify. He was consistent. Consistent, inconsistent. Keep that in mind. Okay. Let's talk about her claim, what she said, that she wants to be with her children. And I don't blame her. All children should have both parents in their lives. But her idea of the best way to defend herself was to pull a gun. Her own life and her mind was at stake. Well, what about the lives of the children? She's got a loaded gun there within the immediate vicinity. Why was she not thinking about that? Okay. Let's move on as well.
2 minutes.
Thank you, Your Honor. What did we talk about during jury selection about proper gun safety, gun handling? We all agree you do not ever point a gun at someone unless it is your intent to use it. Thank God she didn't, because it takes that quick of an impulse to do so, and things could be very different right now. Thank God she didn't do so. Okay. That still does not excuse her behavior, though. Okay, it still does not justify her actions. Her actions must be held accountable. Okay, that's why the laws are in place, ladies and gentlemen, to hold people accountable, keep the community safe, keep the public safe from acts like that. Okay, because of that, you have to decide. I'm not asking you to decide that she's a bad person. I'm just asking that you tell her that what she did was not an appropriate response. Hold her accountable. Protect the public, protect its citizens. Because of having found and proven that she has been committed these two crimes, what you need to do first, then when you get back to the jury room, is say which one amongst you is going to be your presiding juror. Once you have selected your presiding juror, you begin deliberations, and it should be easy. Again, easier case than you think. Do not make it any more complicated than it needs to be. But you're going to get this verdict form. Okay, that's in the back of the jury charge. You're going to go down and say verdict form. You're going to circle guilty. Presiding juror signs right there. Count 1, count 2. Same thing. Aggravate assault with a deadly weapon. You're going to circle guilty. Presiding juror sign. Done. Tell her this is not acceptable. We cannot have this in Bear County. Thank you all so much for your time today.
All right, thank you, ladies and gentlemen. Deputy Laura is going to take you to the back.
And I'm gonna ask the two